Alright guys, welcome back to my channel. Hopefully you guys enjoyed the other video. This is a continuation of the trustee, officers, and agent section, which is section 5 of American Jurisprudence, volume 13, business trust. This section is going to be broken up to 3 videos. The first one I already made. This will be the second, and then I'll be making a third. I did not realize how long this actual section was. So, and I don't want to make these excessively long videos to where I put people to sleep. So to continue, this is part 2 or section 2 of that of section 5, right? Or subsection. Section 54, making contracts and incurring debts generally. Like I said, this applies to trustees, agents, and officers. The section, at least. In the performance of their duty to hold and manage the property of the trust, the trustees of a business trust may incur debts and make or ratify contracts, binding on themselves personally, and instruments creating such trusts sometimes authorize the trustees to bind the trust estate thereon, which of course is true. The authority to enter into a particular contract may depend upon the construction of the trust instrument, but a provision of a trust agreement prohibiting the expenditures of over a certain sum without the approval of the trustees has been held not to be binding on third parties or creditors without notice thereof, which should be a given, right? That was a short section. This is supplement. They just give you the practice aid, legal forms number 15. I don't have this book. I have 15A. Right, still volume 15, but there's a volume B that goes with it. Mine goes up to 210. So I need to get the other book. Footnotes. Let's see. A trust instrument empowering the trustees to deal generally in hides has been held to authorize them to enter into future contracts involving hides. Right, that's the implied power. Right, one power gave an implied power. Section 55, acquisition, administration, and disposition of trust property. Ownership of the property of the enterprise by the trustees is one of the principal features distinguishing business trusts from partnerships and other forms of organization. Indeed, it may well be a prerequisite to the formation of a true business trust. In any event, the trustees are generally vested with the legal title to the trust property, and in determining the nature and validity of the title to trust property, the trust agreement must be taken into consideration. A deed to a trust has been held not to be invalid because the grantee was designated by the name of the trust without naming the trustees, where the trustees were parties to a trust agreement and could thus be identified. Although an early authority has questioned whether a business trust is such a legal entity as can take a grant of land. I don't know what this EO, I think that's a misprint. EO nominee. Land of nominee, to nominee or something. Or to a nominee. The trustees may acquire and hold title to property on behalf of the trust estate. You know what? We want to know something. If you guys find a law book, this law book specifically, right? Especially since this is 1998, and you go to this section and find this error, and if you could find like 1 or 2 more, they'll send you a new book. They'll send you it for free for, letting them know about their errors. And they'll fix it, The trustees may acquire and hold title to property on behalf of the trust estate, even in a jurisdiction denying the right of shareholders or trustees to relieve themselves of personal liability for the debts of the trust. So this, of course, applies to jurisdictions that do not allow you to limit your liability, whether you're a trustee or a beneficiary. It's all dependent on the jurisdiction. And the retention by the sesquiu trustant and the retention by the sesquiu trustant of the power to remove a trustee, to fill vacancies among the trustees, and to direct or control the action of the trustees has been held not to invalidate the title. So just because they have control doesn't mean that the trustees still don't have title. Invalidate the title of the trustees, at least where the beneficiaries have never exercised such power. It has been said that if a business trust has acquired property which the law of the state does not permit such an organization to hold, the matter is the concern of the properly constituted state official and cannot be availed of by one who has conveyed property to the trustees in exchange for shares of the trust. Let me repeat that. It has been said that if a business trust has acquired property which the law of the state does not permit such an organization to hold, the matter is the concern of the properly constituted state official and cannot be availed of by one who has conveyed property to the trustees in exchange for the shares of the trust. So that's like a statutory restriction, and you would have to be in communicate with this guy. Trustees are affected with notice to their predecessors in office regarding defects in title. Footnotes. Hopefully the footnotes give something better, because I would probably want to read these cases for more information. If you guys have information, I would want to read the cases. Like number 7, they don't give no footnote, just a case. It's a Kansas case, and that's important. Jurisdiction is important. Like here, like this right here. This is an Illinois case. It is doubtful whether trustees would be charged with the knowledge of one of their number who sold property of the trust of the existence of a mortgage on the property, since the interest and dealings of such trustee are antagonistic to the interest of the trust. It's a trustee who did something on his own, which is also why it's important that you have powers that are executed together, not, by themselves. You never know what that trustee might do. In the case of an ordinary trust, the power to lease trust property may be implied as a necessary to proper incident to the express powers and duties conferred upon the trustee, and there would appear to be no reason why this principle should not be applicable to a business trust. Instruments creating this type of trust frequently contain provisions expressly authorizing the trustees to lease property of the trust and to obtain property under lease, while ordinarily the term of a lease should not extend beyond the limits placed on the duration of the trust. And this is all with not perpetuities, is alienation, right? To alienate property on the beneficiary. Like he has rights in that property, and when the trust dies, his rights are supposed to be should die too, right? But if there is still a contract out there, right, well, that brings other legal ramifications and there's a lot of restrictions in the statutes or liabilities, I would say, that for one not to do this, to extend it past the duration. But again, it depends on the jurisdiction that you're in. It has been held that where the trustees are vested with full power to sell, convey, or lease the trust property, they may lease such property beyond the term limited for the duration of the trust. And like I said, it's going to be dependent on the jurisdiction. So first one tells you to look, the footnote 11 tells you to look on the trust law book, section 472. And then they give you a court case, right? Lease of gold mining claims for a term of 12 years held valid although the trust was limited to 5 years. But the cases are different. Here you have an Alaska case, and then this is for ordinary trust. This is a principle of ordinary trust. That would be the difference. Instruments creating business trusts frequently contain provisions expressly authorizing the trustees to execute mortgages of trust property to secure debts of the trust estate. It has been said in a case involving a business trust that a trustee cannot create a lien on the trust estate in favor of a creditor without express authority in the trust instrument. However, under principles applicable to trust, generally, the power to mortgage the trust estate may be implied in the absence of an express provision to the contrary, where it is reasonable and necessary for the execution of the trust. And like I said, it's just certain powers give you implied powers, right? You might not state it specifically, but if you don't know what that power is and the effects, that it arises of having that power or using that power, right? This type of thing happens, right? Because it's reasonable, and like when you have a provision saying that the trustees have all powers that are reasonable and necessary for the execution of the trust, well, what is it that you're saying? You're almost saying that you're including all the implied powers also, which if you don't know what it is specifically, that powers that you're conferring, right, that could lead to trouble also. But clearly, a trustee has no power to mortgage real property of the trust estate to secure his personal indebtedness growing out of the transaction independent of the trustee, which that's a given. Arm's length transactions, or self-dealing, that's the term. Annotations I already read. I'll read this one, footnote 10. While the creation of the trust and the conveyance of land to trustees for the purpose of farming and ranching business does not authorize them to execute oil or mining leases, the power to make such leases may be included as a separate power of attorney in the trust instrument. And this is a California case. Well, it's out of California, but it's a federal case. In the instrument, remanded on REH. I don't know what REH stands for. Section 57, sales and conveyances. Generally, the trustees of a business trust are given the power to make contracts for the sale of trust lands which need not be conferred in direct or express terms, but may be implied from the purposes of the trust. The trustees in whom title and control are vested can convey a good and marketable title to real property belonging to the trust estate, and apparently may sell such property at private sale rather than by public auction. However, subsequent purchasers are charged with notice of limitations contained in the trust instrument upon the power of the trustees with respect to the conveyance of the trust property. Generally, where title to trust real property is vested in the trustees, other officers of the trust cannot sell or convey the property. Why? Because officers are agents. They're ministerial. They don't have that duty. They don't have that obligation that a trustee would have. Like even if the trustee was the manager, was that an officer, right? Well, as a trustee, you should have written up the duties and the powers of that officer. And that would also constitute that in that capacity, as that officer, he cannot sell or convey that property unless what? You gave him permission to. But where contracts for the sale of land are made in the adopted name of the trust by the duly designated managers thereof, the contracts are not subject to the objection that the real vendors are the trustees, that they are undisclosed principals, and that hence the contracts are unenforceable, which they will be because they were what? Duly designated, meaning you specifically gave them those powers. or some powers that you gave them an implied power. Trustees may be compelled to specifically perform a contract for the sale of an interest in real estate by making a conveyance thereof. Trustees may be compelled to specifically perform a contract for the sale of an interest in trust real estate by making a conveyance thereof. Supplement, sale of trust property for provisions right here. Here's another one, trust instrument authorizing sale or disposition of property. Footnote 1, holding that a provision of a trust instrument vesting in the trustee the sole power of alienating and conveying the property of the trust for value does not authorize him to donate such property to others, to sacrifice it in a manner contrary to his fiduciary obligation to the beneficiaries of the trust, or to dispose of it otherwise than for their benefit, which should be a given. Holding that directors, footnote 2, holding that directors, as distinguished from trustees, had no power to dedicate trust lands to the public. Another case, holding that a contract entered into by the president and secretary of the trust for the sale of land of the trust was not binding. And this is literally because, as an officer, right, a ministerial duty, they were not given those powers. A sale of trust lands by the general manager of a trust who was its alter ego and exercised complete authority and control over the trust was held to be a sale by the trust itself. Holding that specific performance may be required of the trustees, although the contract was originally made irregularly and not at any formal meeting of the trustees where it was subsequently ratified by the trustees. And that's that last one. Trustees may be compelled, right, to perform. And this would be an example of one. Section 58, making and issuing evidences of indebtedness. Trustees of a business trust may, of course, execute bills and notes binding upon themselves personally and are sometimes expressly given the power to execute such paper binding upon the trust estate. Now, when they're saying themselves personally, they're not saying themselves personally like an individual, because the sentence states trustees. So they're saying personally as trustees, because you can hold title and hold property and execute things in the name of the trustee. But as long as you are functioning as a trustee, then it also reflects the trust. It's just that in this case, it's upon the trustees personally. And some jurisdictions do that, or have statutes that, are for that, or pro for that. For power, such power may also be implied from the trust instrument. For instance, a declaration of trust empowering the trustees to mortgage trust property necessarily carries with it the power to sign and deliver obligations of the trust to secure which the mortgage is given. The failure to comply with a statute requiring the trust instrument to be recorded has been held not to deprive the trustees of the power conferred upon them by the terms of the trust to execute promissory notes. So it doesn't stop that power, right? Because it's a private power, right? But if you're doing something in the public, right, where that promissory note is going to be sold and traded and whatever in the public, dude, then the statutes come into play. There is no doing something in the public without one thinking that it's not going to be regulated in some way. And this is involving a Florida law. They don't give no information about that, but it's a Florida case. Section 59, compromise and settlement of claims. Trust instruments often authorize the trustees to compromise claims or demands of or against the trust estate. Under a business trust agreement empowering the trustees to compromise any claims, they may compromise and settle claims or actions against the trust based on torts of the trustees which the trust estate derived a substantial benefit, and may use the trust funds for settlement of such claims. I'm going to read this again. Right? Trust instruments often authorize the trustees to compromise claims or demands of or against the trust estate. Under a business trust agreement empowering the trustees to compromise any claims, they may compromise and settle claims or actions against the trust based on torts of the trustees from which the trust estate derived a substantial benefit, and may use trust funds in settlement of such claims, which is a given, right? They only got one footnote. Involving trust instrument authorizing the trustees to develop and operate oil wells, to exercise exclusive management and control of the trust estate, and to employ counsel to prosecute, defend, or settle actions, and to compromise or refer to arbitration any claims in favor of or against the trust. Right here, the way this is written, that's a provision. This is, I could use this. I would just rewrite this and put it in my document right here. They give you annotation right here. American Law Review 156, page 150. Subsection 60, assessments. Instruments creating business trusts sometimes contain provisions authorizing assessments against shareholders. A trustee may maintain an action against the members of the trust to recover assessments made by the trustee against the members, where the assessments are reasonable and necessary and were made in accordance with the trust agreement. But power vested in the trustees of a business trust to make certain assessments against shareholders and to require them to pay the assessments does not empower the trustees to forfeit stock of the shareholders not paying such an assessment. And such a forfeiture is void in the absence of some authority therefore in the trust instrument. So they can't just do it willy-nilly. They have to be authorized to be able to take away their shares. Right? The power has to be in the trust instrument. And this only applies, it doesn't apply to no family-oriented business trust. This is one that you are selling your shares for investment purposes. Right? That's how I would look at this case. This interpretation right here. In any event, in order to effect or validate a valid forfeiture of shares in a business trust for non-payment of calls or assessments made by the trustees, they must comply strictly with the provisions of the trust instrument with respect to notice to the shareholders. So that's another one. You have to give them notice. Like just because they're delinquent on a payment, right? Say if you sold them shares for $1,000 a piece and it's a monthly payment of $100 a month and they missed a couple payments, well, you just can't you have to comply with the provisions of the trust instrument for sure. So if the trust instrument says you should give them notice, well, then you need to give them notice first. If the trust instrument says that after you gave them notice, say 3 times, and they still don't pay, now you got the power to what? Take away their shares, to make them void. But that's, again, if you, as the grantor, wrote that. All right, that was the end of that section. This is Part C, Duties and Liabilities. Part 1, to the trust and shareholder. So this is duties and liabilities to the trust and to the shareholders. Subsection 61, generally fiduciary relationship, which everyone should understand here. The relationship between the trustees and beneficiaries of a business trust is comparable to the one existing between the directors of a corporation and the corporation itself, but is more confidential in character. Why? Because it's not public, or it's not a franchise of the government. In essence, it is a fiduciary relationship regardless of whether the organization is classed as a pure trust or as a partnership with respect to the rights of outsiders. And the trustees owe a fundamental duty to act for the promotion of the interest of the shareholders, Acts of a trustee contrary to the best interests of the shareholders are not absolutely void, but voidable upon at the option of the beneficiaries. So like even certain acts, right? Right, that would be considered against the shareholders, right? They might not be void, especially if the shareholders have knowledge of that act and then don't do nothing about it, right? What it said in the last video, right? Where acquiescence, they gave acquiescence, but that was pertaining to the trustees, right? But here, pertaining to the shareholders, if the beneficiaries don't do nothing, that means what? They accepted it. There's an example now of someone that, well, I'm not going to get into that, but there's an example now of someone that I know that's something like that too, right? Where the one of the trustees did a sale of property, right? But no one gave an objection to it. And now it's just way too late. You're talking about months, years almost, and it's still in court. The fiduciary relationship existing between the trustees and the beneficiaries of a business trust imposes upon the trustees a duty to act for the beneficiaries and not for themselves in antagonism to the interests of the beneficiaries, which is a given. Accordingly, trustees must manage the assets of the trust for the benefit and advantage of the shareholders and not with an eye to their own personal advantage or profit. A trustee of a business trust may not profit by any transactions in relation to the trust estate at the expense of the beneficiaries, nor is he entitled to derive any profit out of the trust. And this is what I was saying in the other video, right? The income, the profits are meant for the shareholders, right? Now, can the trustee take compensation out of the income, out of those profits? It has to be a yes, but does that raise liabilities is the question. Why, and is it also necessary? It's not necessary. Why? Because he could be compensated out of the corpus of the trust. So it's like, to me, this is a potential liability when the trustees get compensated out of the profits itself. Unless, but I do know that expenses can be taken out of the income, so it's all dependent on the jurisdiction for sure. Except as lawful compensation, right? So nor is he entitled to derive any profit out of the trust except as lawful compensation, which is an expense. And we'll look that up right now, number 19. They didn't give nothing. They just gave a court case, a federal case out of California. They took it to the Supreme Court and they got denied. Such an act being voidable only may be either affirmed or repudiated by the beneficiary, like I said. It's only voidable only if these things happen right here. But a stranger to the relationship between the trustees and the beneficiaries and to the question of title as between them cannot assert the invalidity of the act of the trustee in acquiring property as agent for a third person. So somebody outside the trust can't void it, can't make it voidable. Now, could he go tell the beneficiaries and give them all the information that they might need? Of course he can. It's still up to them to go and do it. The trustee has no right to dispose of or to encumber or to use trust property for his own personal benefit, nor may he speculate on the possibilities of property of the trust at the expense of the trust. Let me repeat that. He has no right to dispose of or to encumber or to use trust property for his own personal benefit, nor may he speculate on the possibilities of property of the trust at the expense of the trust. So this is big right here. This is 21, 2, and number 3. Let's see what they give. An Arkansas case, mortgaging trust property to secure trustees' personal debt, right? So he's screwed right here. And that was a Oklahoma case. Right here, there's a Texan case holding that a bank having actual or constructive notice that the trustee was commingling the funds of the trust with his own account at the bank and was using the commingled funds for his personal purposes was liable to the trust for the sums thus misused, which is a given. And I know someone who's doing that now. He was given a ministerial duty of managing properties, right? And he was commingling funds with his own personal life. Now, he was never called on it, but nonetheless, that was what he was doing. He could be held in account if the court ever finds out. That's footnote 4. I'll read that later. The trustee of a business trust is impliedly prohibited from purchasing on his individual account property necessary for the business of the trust or for carrying out purposes for which it was organized. So he's prohibited from his individual account. He may not act for strangers adversely to the interests of the trust, which should be a given. Let's read this number 4, though. This is a Arkansas case. He cannot elect to make a good bargain for himself when, by fidelity to his trust, he could make the same bargain for the benefit of the shareholders. The principle by which a trustee is disabled from profiting personally at the expense of his trust does not apply to a transaction by which trustees of a business trust acquire for themselves the shares of other shareholders. The trustees cannot be compelled to account for the proceeds realized from the sale of their own interest in the business trust, legally sold by them in connection for their agreement to resign as trustees. That's because a shareholder can be a beneficiary. A trustee can be a beneficiary too. And in that capacity, he has the power to sell his interest whenever he wants, just like any other person. Let's see the supplement. Here's a practice aid. Financial institution directors mitigating risk of liability in shareholder actions. And they give you a court case. I do not know what this notation is. LJ. Bank LJ 336. Never heard of it. Law, I don't know. I don't want to make it up. I would have to ask at the law library. Again, 88 American Law Review, 3rd edition. Complaint in action by shareholders for accounting by trustees. And they give you the pleading and practice forms. The footnotes I already read. I didn't read 5 though. Stating that the trustee of a trust engaged in the business of mining has no right to locate a mining claim as agent of the third person and for the latter's benefit. Because he's doing it in favor for someone else and not the trust. Subsection 62, care and skill required, liability for negligence or misconduct. Generally the measure, and this right here, this care and skill, right, in the conduct of your administration of the trust is not the same for the care and skill and prudence or whatever other term they use for investment purposes. They are two different things. Generally, the measure of the care and diligence required of a trustee is such as would be exercised by a man of ordinary prudence and skill in the management of his own estate. He is not an insurer. Let's read with that because they gave like a 5-sentence statement right there, a 5-word statement. and they give nothing, but they give trust. Go look it up under Ordinary Trust, Volume 74, American Jurisprudence, page 322 and page 414. The principles apply to the measure of care and skill required of the trustees of a business trust. While ignorance on the part of the trustees of a business trust of the scope of their duties or of the legal requirements connected with their office is no excuse for their failure to discharge that's basically ignorance of the law. Is not an excuse. Scope of their duties or of the legal requirements connected with their office is no excuse for their failure to discharge their duties with reasonable skill, prudence, and judgment. When trustees act according to their best judgment and in good faith, they should be protected, though they may make some trifling mistake in doubtful matters. A mistake is not negligence or misconduct, unless it's shown otherwise, but it's a mistake. The trustees of a business trust are liable for losses resulting from their willful breach of trust or diversion of trust funds, and for funds of the trust used by them for purposes other than trust purposes, and may be liable to an accounting for their improper dealing with trust property. However, there is no such liability where the loss of the trust is not due to any fault or negligence on part of the trustee. And it has been held that the inaction of a trustee does not constitute a breach of his duty to the members or shareholders, where, by the trust instrument, he has no authority to act without the consent of the majority of the shareholders. So that's specific. He either did or didn't do something, but it's only because he had no authority in the first place. They can't hold him accountable for something on an action to do something when he had no power in the first place. But the failure of a trustee to insert in contracts made by them a provision exempting shareholders from personal liability has been said to subject the trustees to liability for any loss sustained by the shareholders as the results thereof. And this is right here, it's because why? A principle of just general trust law. Trustees are held liable. The only thing that changes that is contract law. Meaning in the contract, there's a provision that exempts them. But it also has to be stated in the contracts. In the contracts that you are executing on behalf of the trust. An officer of a business trust vested with the sole management and control of its affairs is liable to the trust for loss and damage resulting to it from his negligence and fraud. Of course, you gave him that power. That you put him in a fiduciary position with the powers you gave him. Trustees are not estopped to maintain an action against former trustees based on improper dealings by the latter with trust property, where there was nothing of any nature to show either knowledge of or assent to the acts of the defendants. We'll read that footnote. Holding that the trustee has no authority to erect or repair houses upon the land belonging to others, under a provision of the trust instrument authorizing the erection and repair of buildings upon land belonging to the trust, and the use of trust funds for those purposes constitute a wrongful diversion thereof. So what is it? The trust owns land, and he's permitted to do repairs and whatever else on that land. He can't do it somewhere else. I mean, that's a given. The power not is general, the power is specific on that property. A former trustee is liable to the present trustees of a business trust for wrongful diversion of the trust. Footnote 18. Holding also that such an officer cannot escape liability to the trust for the consequences of his negligence and fraud, even if the organization is treated as a partnership. on the ground that there must be an accounting among the members of the partnership, or on the ground that the trust instrument exempted the shareholders from personal liability. So he's still screwed, right? Negligence and fraud, you're not escaping that. Section 63, trustees dealing individually with trust or shareholders. While transactions between the trustees of the business trust and the beneficiaries are not prohibited, sometimes are expressly authorized by trust instruments. Such transactions are subject to close scrutiny, and courts of equity will set them aside on slight grounds. In his dealings with beneficiaries, the trustee is held to the highest degree of candor and frankness. He must not only be strictly truthful in all his representations, but must not remain silent concerning any matter of which he has knowledge that would throw light upon the trust estate, which this should be a given. If you're doing business with them, you're not looking to deceive them. You have a duty to protect them in all dealings with them. You don't do this, you're held accountable for that. The manager of a business trust, in making a loan to the trust, is charged with the knowledge of the provision of the trust instrument. Because he's supposed to, you hire this guy with specific duties, you have to give him that knowledge. A deed of trust executed in good faith by trustees to secure the payment of a loan for the benefit of the trust, negotiated by part of the trustees on their individual responsibility, is not absolutely void. A trustee of a business trust, in the presentation and consideration of his individual claim against the trust estate, cannot vote as a trustee upon the approval of the claim. If his vote is necessary to secure favorable action. Why? Because that's called self-dealing. Let's see what the footnotes say. The acts of trustees of a business trust in purchasing for full value in the name of a corporation which they controlled notes of the trust secured by the mortgage on trust property, after having failed to procure a renewal thereof, were held to constitute a breach of their duty, and the property thus acquired by them was held to be impressed with a constructive trust in favor of the other beneficiaries on payment by the latter of their portion of the price paid for the property. Can't do no self-dealing, bro. At least in the absence of a verified pleading setting up lack of authority in the trustees. Holding that where the trust instrument required that 2 of the 3 trustees act in order to bind the trust, action taken by 2 trustees in approving a claim submitted by 1 of the trustees on behalf of the corporation, which was merely an alias under which such trustee conducted his private business against the trust, was invalid and did not afford the basis of any action on an account stated based on the approval of such trustees. To the same effect is involving a contract for the extension of an agreement between the trust and a corporation in which one of the trustees was interested. And if you read these cases, right, there's nothing that stops a trustee from being able to hold shares of a corporation or any other entity outside of the trust in his personal and individual private capacity, right? The thing is, though, is how much power does he and control does he have in that corporation, which would violate his fiduciary duty within any interactions or transaction that he has with the trust and the corporation. That's the catch. I forgot it's coming up, I think, still in this one. I know it's in the other book, but I think it's still coming up here. Sale of trustees' property to trust. So this is your property, selling it to the trust. or the trustee's property, right? Where complete disclosure is made to the shareholders. The trustees of a business trust may sell to the trust for shares therein property acquired by them prior to the organization of the trust, even though at the time the persons who later became trustees had agreed on the organization of the trust and upon the principal provisions of the trust agreement. However, a trustee is liable to an accounting to the trust for profits wrongfully made by him from a transfer of property to the trust, though through misrepresentations as to the cost of the property, and fraud on the part of the promoters and trustees of the business trust in grossly misrepresenting the value of a lease transferred to the trust in exchange for its stock and cash has been held to be a ground for a suit by the shareholders to cancel the transfer of the lease, to rescind their contracts for the purchase of shares, and to recover the price paid for the trustee for the shares. Footnotes: as in such a case, a trustee is not entitled to credit for the expenses of an improvement erected on the leasehold estate, since the cancellation of the transfer to the trust, the benefit of the improvement will inure to the trustee to whom the lease reverts. So there's a reversionary interest here. Section 65, rights in property or benefits acquired by trustees. Where a trustee of a business trust acquires a debt or claim against the trust estate, or acquires an outstanding title to trust property, the purchase inures to the benefit of the trust estate. The purchase inures. Let's look up this word specifically now. Inures. Accustomed to something, especially something unpleasant, to come into operation, to take effect. That's the proper one. Similarly, any profit made by trustees out of the trust ordinarily inures to the benefit of the beneficiary. Thus, trustees who accept a new lease in substitution for one owned by the trust estate are liable to the accounting to the shareholders for the proceeds realized and wrongfully retained. Where trustees of a business trust acquire in their own individual names or on their personal account property necessary or appropriate for the business or purposes of the trust, the property will be treated as being held in trust for the benefit of the shareholders upon their payment of the purchase price. And the same principle has been applied to property acquired by the trustees for the benefit of a third person. However, the trust has been held to have no right to recover an oil lease which the trustee, in violation of his duty under the trust agreement, took in his own individual name and transferred to another as against a bona fide purchaser of the lease for value and without notice of the claim to the trust. Footnotes: where some of the trustees of a business trust purchased in the name of the corporation controlled by them the mortgage on this I read already. Did I? No, I didn't. Yeah, I did. Where some of the trustee of a business trust purchased in the name of the corporation controlled by them the mortgage notes of the trust, after the failure of the trustees to procure a renewal of the notes, the purchase by such trustees of the trust upon trust property upon foreclosure of the mortgage was held to be impressed with the trust in favor of the other beneficiaries of the trust, and each of the beneficiaries was held to have a right to share in the benefits of the purchase on the foreclosure upon payment of his share of the consideration. I'll have to read that case to understand that one. They got denied in Missouri by the Supreme Court. The Supreme Court wouldn't even look at it, right? Certiorari denied. However, the right of shareholders to share in the profits of such a purchase depends upon their payment of their proportionate share of the purchase price, and the right may be lost by their failure to assert the same in an appropriate proceedings. Right? Because the whole concept of proportional share is how much you have been, at least the shareholders, how much they have been vested with the shares. So if their proportional share is supposed to be $1,000, right, of the purchase of a share, but they only paid $500, which is half, then their proportionate share of any income should only be half also. This is the oil fields one, wherein it appeared that the trust instrument was recorded in one county, but not in the county where the leased property was situated. I think that ends it for now. Yeah, this is what ends it for now. So the next section is going to be involving third persons. And that will be the end of this section 5. After the next video, it will be the liability of trust estate and availability of trust property to the creditors. But the next video is going to be the trustees, officers, and agents liability to third persons. So hopefully you guys enjoyed this video. If you guys have any questions, always feel free to ask. I'm always open for questions. And that'll be all. Until next time, guys.